Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Melissa Maxman. Today's topic is, what are the thoughts behind the changes? On July 19th, 2023, the U.S. Department of Justice's Antitrust Division and the Federal Trade Commission issued a set of much anticipated draft merger guidelines. These were aimed to modernize government scrutiny of merger activity and to replace the agency's prior policy announcements, including the 2010 horizontal merger guidelines and the 2020 vertical merger guidelines. The agencies are now taking public comment until September 18th, 2023, and many of you, as I'm sure you know, are eager to understand how to best approach the draft guidelines and, more importantly, the thinking behind them. Joining me today is my co-host, Anora Wang. Hi, Anora.
Hi, Melissa.
Who are our guests today?
The two guests joining us to this very important discussion today are the DOJ Antitrust Division's Deputy Assistant Attorney Generals Andy Forman and Michael Kades, both focusing on civil enforcement and have been deeply involved in the process for the current draft merger guidelines process. Prior to joining the DOJ, Andy was in private practice, being a partner in the DC offices of two major national law firms, focusing on merger and conduct matters before federal, state, and foreign antitrust authorities. Earlier in his career, Andy also helped lead antitrust and merger enforcement teams at the FTC and worked as a judicial law clerk. As for Michael, prior to joining the DOJ, he was Director for Markets and Competition Policy at the Washington Center for Equitable Growth, where his research focused on competition and antitrust enforcement. Before that, Michael had already accumulated over 2 decades of experience in antitrust policy, including working as antitrust counsel for Senator Amy Klobuchar on detail to the FTC and as an attorney within the FTC investigating and litigating antitrust actions.
Great. Thank you, Anora. And without further ado, Andy and Michael, thank you and welcome to the program.
Nora and Melissa, it's a pleasure to be here. I actually think this is my third time. Is it this like Saturday Night Live? If I get to the fifth time, I get a jacket.
We'll have to look into that.
Yeah, I don't have Kades' Saturday Night Live experience, but thanks for having us. Looking forward to the discussion.
We're going to invite you coming back in the future.
Exactly.
Good.
We know that you're very busy and we're grateful that you're going to take time to walk our audience through the draft merger guidelines, which in all include 51 pages and 13 individual guidelines for assessing M&A activity. Anora, do you want to start off?
Yeah, we have a lot to unpack, as you know, and we might not be able to get through everything, but I think we should start with some basic background. So from the DOJ's perspective, very simple and fundamental questions. Why are the draft guidelines needed? What are the underlying principles and thoughts behind the policy changes that they will bring? Michael, why don't you start?
Sure. So, yeah, a couple of reasons. The guidelines obviously been critical to merger enforcement since they were first issued way back in 1968, but they always have periodically been updated and changed as we get new learning. And so, really on the last time the government looked at it, how it looks at what we would call or have called horizontal merger guidelines, right? Those were 2010, so it's been a while. And I really think sort of three or four key points here. The first is, I think it's really important to us that we tie what we're doing in enforcing the law to enforcing mergers, investigating and enforcing mergers. That's tied to the law. What I guess we here talk about fidelity to the law. And, I think making that explicit, which is a development in these guidelines, is really important. The second thing is being transparent. These guidelines reflect what the staff and leadership is thinking about when we're looking at mergers, the questions we're asking. And I think making that clear and in that way incorporating into the law the most modern economics is important as a matter of transparency. And I think the big substantive point is really thinking about, when we're thinking about mergers, right, it's thinking about how does competition present itself in a market? How does the transaction change that? And, what is our assessment? And so, I think it's those 3 points of fidelity to law, transition, and analyzing the economics, the markets as they exist. Andy, everything to add, or if you want to, grade me, that's fine too.
No, all that of course is right. Just to add on a few things. I mean, look, as Kades said, the guidelines have been updated, periodically since 1968, and these guidelines, while there certainly are some differences, stand on the shoulder of a lot of the previous guidelines. But as Kades indicated, I mean, the last time the horizontal merger guidelines were updated, my daughter, who I'm about to drop off at college in a month, was in preschool, and so, and there's all sorts of similar analogs if you want to bring out technology, what technology was like then versus today. But one of the main goals, in addition to fidelity of the law and drafting the guidelines in a user-friendly way and being transparent about how we're doing it, is to make sure that they really do reflect how competition presents itself in the modern economy, as Kades said. And so, we may get into this further, but things like we're seeing more and more competition, a platform is involved, and that can present unique and distinct issues in a merger review. Also, this set of guidelines combines essentially what traditionally has been the horizontal and vertical merger guidelines into one set of guidelines, because while the horizontal and vertical construct may be useful in certain industries, still in a growing number of industries and deals, competition presents itself in a much more complex and distinct way. As our Assistant Attorney General likes to say, instead of horizontal and vertical all the time, competition sometimes presents itself like a prism, or a light coming through a prism, or a gemstone. And so making sure that we have transparent guidelines that reflect the law and precedent, but also reflect modern economics to account for those changes was a driving force.
I like all 3 points that you've made: fidelity of the law, and then transparency. And the third, you said, modernize that and analysis maybe to capture, I guess, mergers and acquisitions not necessarily squarely fitting horizontal or vertical. You call them prism or gemstone. I call them 3-dimension chess. So maybe that's how the guidelines are intended to capture. But let's
use that one too.
Yeah. Can I get credit for that? Let's start with transparency. I think that's something to be applauded, right? So is the DOJ Antitrust Division already engaging in merger analysis as described in the draft guidelines?
So the answer to that is yes. I mean, the concepts in the new guidelines are certainly concepts that we evaluate today. Obviously, we're in this interim period where there are also guidelines. By the way, the previous guidelines, horizontal guidelines, have not been withdrawn. So, and as you pointed out at the top, these are draft guidelines. They do not in and of themselves reflect the law. And just taking parenthetically, there is a 60-day comment period. We really do urge people to review the guidelines closely and provide comments. It was an important part of our process to make sure that there was a robust notice and comment period, and we want to hear from people. But the concepts in the new guidelines certainly are factors that the agencies are taking into account today when a merger comes across their desk.
So I think the draft guidelines are not coming as a surprise, right? They are largely consistent with the policy direction under the Biden administration, and as signaled fairly clearly and loudly maybe in the past 2 years. So I think that's really good. Let's look at some of the more specific changes in the draft guidelines just to better understand them. Would you share what improvements those changes would make? And we do hear questions about some specific thresholds and standards for presumptions and analysis. So maybe this is an opportunity for you to explain that. So start with the second point I think you've made, which is fidelity of the law. And I think that, it's tied to the question of the rule of the law, right? We keep hearing that this set of draft merger guidelines are based on what the antitrust laws actually are in statutes and litigated cases. Is that the case? And how so?
I think the way to think about this, right, is there sometimes, and I don't think this was an intent of any of the prior guidelines, but it becomes what the guidelines, what's said in the guidelines becomes, then this is the only things the agencies are interested in, right? And if you go back to the case law, it is quite clear that the courts in interpreting the Clayton Act had a much broader view of concerns to think about, right? And so we think about, right, it's not solely a question of defining a market, doing a concentration analysis, leading presumption, thinking of coordinated effects, unilateral effects. Those are obviously important. Those are still important. Those are, we're not at all backing away from that. But, right, if you go back, the case says, like, look, there are other ways competition can be affected. It can be affected, if a situation where there's a trend to where in the right circumstances, a trend towards concentration can be the basis for seeking liability. I mean, the law hasn't changed, but that is a question we will be thinking about, and we think that kind of question, for example, is more relevant in today's economy than maybe it was 40 years ago. But again, it's not the law that's changing, but that law has been said that you need to think about how competition changes. And it's more than just simply there are more ways to ask that question than were necessarily in the prior versions of the guideline. I mean, sort of a way in which I think there's actually continuity. If you go back, although unilateral effects, right, was in the guidelines, I think at least since the 90s, it wasn't a big part of it. And the government ran into people sort of complaining about, unilateral effects wasn't something that was really justifiable. And what I think one of the great benefits and developments of the 2010 guidelines was really to lay out how we think about unilateral effects, why we're asking those questions, and how we analyze that. And in many ways, this version of the guideline is just adding other types of questions we're asking. Andy, got anything to add?
Yeah, just to maybe layer on at a higher level even. I mean, I think, taking a step back, Congress has made a value judgment that competition is important and that protecting competition in its incipiency in the merger context is important. And so they wrote this statute, as a part of the Clayton Act in the early 1900s, and then it got it got augmented in 1950. And then, based upon that value judgment, there were several cases thereafter that the Supreme Court and others, analyzed. And, those legal principles that coming out of those cases are still good law. The DC Circuit even recently has remarked that, still good law. Defendants, and the agencies cite those cases for the legal principles all the time. And so, Jonathan and Lena, I believe, in sort of organizing how to approach the guidelines, said, well, look, let's make sure we sort of take a step back and really reflect on what the law says as written by Congress and as interpreted by the Supreme Court and courts of appeals. And then obviously include modern economics and, guidance on how the agencies sort through these issues. And so that really is as we've said a few times now, a core part of the document and a core part of our sort of ethos as law enforcers, right? We enforce the law, and Congress has been clear about what the law is, and the Supreme Court and courts of appeals, interpret the law. And so as law enforcers, we're bound by that. And so that should be a core part of the guidelines.
Yeah. Well, let me play devil's advocate for a minute. This leads right into one of the criticisms we've been hearing. Some people say that by reaching back to, for example, the old HHI levels and so on, and by reaching back to, as you call them, core principles, you're really using old, outdated, and prior to current economic thinking ideas that aren't appropriate for analysis in the modern economy. How would you respond to that?
Let me add a bit of color. I heard that AAG Canada actually ordered to have every Supreme Court and Court of Appeals antitrust case to be printed out and delivered to his office. And I'm sure he has spent a lot of time reading those. I think it's very commendable effort to do that. And people applaud to the fact that this is for the first time the agencies have cited case law to support the guideline. So it's just like what are the cases to be cited is the question. So people are not so happy to see 1960 cases being cited here. How do you respond to that kind of critique?
Sure. Yeah, I'll go, and then Kades will layer on. And I talked a little bit about this, just a little bit ago. But look, and as Jonathan has also said a little bit tongue in cheek, Marbury versus Madison is still the law of the land too. That's a Supreme Court case from a long time ago. And so, as law enforcers, right, unless the Supreme Court has overturned itself, Supreme Court precedent is still the law of the land. And courts of appeals, obviously, if many of the merger cases, in the guidelines that are cited are courts of appeals too, also provide, guiding legal principles. And so as law enforcers, Congress writes the laws and Supreme Court and appellate courts interpret the law. And that's what, should guide us. We do say, and this is in the guidelines, and we recognize that there are, in some of those old cases, we cite for the legal principles, how the economics of that time were applied to the particular facts at hand, may be different now with today's modern economic thinking and tools. But the legal principles are still good law and can and should guide us. And, by the way, a lot of those old cases are cited by people on both sides of the V in a merger case. We recently lost a case. The Third Circuit ruled against us in a sugar case. And part of the reason we were criticized was because we did not rely enough on the brown shoe practical indicia market definition factors. And the defendants in that case, cited brown shoe and the legal holdings extensively to make that point. And so that's just sort of an illustration where, in our view, the legal principles across a lot of those cases in the 60s and 70s and whatever else, they still apply, and they're relevant for how we assess transactions.
I think we made every attempt to include all cases at the Supreme Court and Court of Appeals level that deal with mergers. We did somehow manage to forget or not include Anthem, but of course that's actually a case the government won. But if people think we are, if there are cases we missed at that level or that we are misinterpreting, then this is what the comment period is for. The second thing, I think in thinking about the law, it's not a ratchet, right? And sort of some of the argument is you're going back to these old principles, and they arguably suggest that the law deals with a broader range of issues, but we don't like those, and we think the economics is they're bad. So I think so you should ignore them, right? But let's flip that, right? So let's say after the sugar case, we came up with these guidelines and we said, we're doubling down. The only way to do a market definition is the hypothetical monopolist test, full stop. We don't care what the Supreme Court said in brown shoe. None of those factors matter. We're just not going to pay attention. Well, one, I'm pretty sure that would not be good for our next case. And two, I'm pretty sure the very people who are complaining about us citing old cases would then say, this is ridiculous. How can the government ignore what the Third Circuit just said in brown shoe? So I think, right, the thing to be thinking about here is, are the principles we're pulling, if those facts exist, are people saying, are those still violations of the statute? And do the guidelines in addressing those ask questions that are realistic ways to assess that? And I think that's the process here, and it's really not an issue of which cases we're citing or whether they're old or new, because as anyone who's litigated antitrust cases knows, that the precedent can be cited in a number of ways, and what we're trying to do is make sense of that and provide a coherent whole in a way that reflects that will lead to merger policy that is effective and deals with competition as it presents itself in the market.
Can I just layer on too? So there's I've heard a couple things, I guess, specifically. There's the notion that the Supreme Court cases in the mid to late 70s effectively overruled the earlier cases. I just don't think nobody's been able to point me to where the Supreme Court says we overruled the previous cases. Number one. Number two, I would direct people who have a thought like that to read the DC Circuit opinion in Anthem, where they actually engaged on this issue. Mm-hmm. And the DC Circuit's majority opinion said, actually, no, they didn't. So, that's one thing. And then the other thing is that I think the criticism has been, well, why don't you cite the more recent district court cases where there have been results on both sides? And, I think the response to that, for thought is, look, these are guidelines. We are citing these for the core, legal principles, again, as reflective of modern economics and how we review transactions. District courts obviously apply facts to the law. They're very, fact-specific opinions. And many of those opinions borrow from, right, the precedential opinions that we're citing for the legal tenets. And so, citing Supreme Court and Court of Appeals precedential opinions struck us that's the way to go.
Yeah. I think this connects very nicely to the third major point that you made in the beginning. The second point being the fidelity of law. And then the third would be like modernizing the analysis that will address competition, not necessarily horizontal or vertical. Could be prism, could be gemstone, could be three-dimensional chess. Now I've made my description into the list and now you have to use it. So I think questions are raised around that too. So people are asking how the draft merger guidelines are attempting to incorporate analysis into, for instance, platform or labor market. Can you go into that a little bit and explain, what are the specific attempts in the draft guidelines to provide guidance on analysis of those kind of situations?
And just for our listeners out there, the platform markets is guideline 10 and the labor markets are guideline 11.
Look, I know there's been some criticism of people suggesting that somehow labor is different than product markets, but I think the law is quite clear that a merger that whose effect may be to substantially reduce competition or tend to create a market in any line of commerce is illegal, and the purchase of upstream markets satisfy that, and so providing more guidance of how we're thinking about labor, I think, is good for transparency. But the other thing to think about is if you look in the research being done, particularly by labor economists, right there, it is pretty clear that market power is very prevalent in labor markets for a lot of reasons. And so both you have sort of the sort of theory talking about why labor markets are a lot more sticky. But then there's just an amazing amount of empirical work, both measuring market power. Now, what does that mean? If you know those two facts, does that mean that every merger is going to be illegal? No. But does it mean we need to think about how a merger affects labor? Absolutely. And really, so we have expanded our explanation of labor markets here as a way to show that we need to be sensitive to how mergers affect labor markets. I feel like this is actually really sort of kind of obvious. So I'm going to stop there and let Andy talk about the more complicated issue, which is the role of economics in platform markets.
Yeah, before doing that, so the one thing I would refer people to on this is, the recent decision by Judge Pan in the Penguin Random House transaction. I mean, that case fundamentally was a labor market case. The theory being that the combination would depress prices for authors who rely on, advances and other things to provide a living for their family. Of course, Stephen King got a lot of fact that he was a part of that trial, got a lot of press. But that case also was about a lot of other authors whose names we don't know, who, we think we're likely to be harmed by that transaction. And so that's a good example of, a recent labor market transaction, obviously where we took action that predated this guidelines, but, may be insightful for people as they review the labor market guideline. On platform markets, so, look, this is totally a reflection of modern economy where more and more, whether it be in tech or frankly other industries, platforms are relevant to the competitive analysis in some form or fashion, and platforms present competitive considerations that are unique, or at least present a wider range of issues that don't make it as straightforward as maybe some of the traditional models might suggest. There can be competition. There's scale issues, there's network effects with platforms. And so as the guideline says, there can be competition between platforms, on a platform, or to displace a platform. And all of that competition can be meaningful and should be evaluated in the context of a potential transaction that implicates a platform. I will say, but take a point of personal privilege here. The lead drafters on both sides of the merger guidelines, DOJ, it was Susan Athey and Dave Lawrence, and on the FTC side, Aviv Nevo and Ken Merber, absolutely fantastic. Susan Athey, who's one of the world's leading economists, is also one of the world's leading thinkers on platform economics and dynamics. And so we're very lucky that, we had all of them, but her in particular, as we navigated this guideline. That's not to say that there may not be able to be improvements, and we urge people to submit them if they've got comments. But given how important platforms are in today's economy, the team felt like it was important to have a section, calling out on that.
Leaving the gemstone prisms recognition and chess aside just for a second, let's come back to the traditional horizontal versus vertical land for a second. So one thing really I picked out from the guidelines is that there is a statement about vertical section saying at or near a 50% share market structure alone indicates that merger may substantially lessen competition. Would you provide a little background about the statement? What's the source of that?
Okay, so look, just maybe taking a step back first before answering that, just to I want to talk a little bit about the organization of the guidelines, just to make sure that it's apparent to folks in a couple different ways. First of all, the guidelines are done in sort of three levels of specificity. There's the overview, which provides, hopefully, is a user-friendly, as it says, overview that if somebody wants to read 3 pages, they can get the gist of what we're saying. Then there is the next, however many pages that is sort of the next level of specificity that goes into we tried to write it in as user-friendly a way as we could, but, there naturally is some antitrust vernacular in there. And then there's the appendix, which goes into even more detail on some of the antitrust tools and the like. And the way that the guidelines themselves, of how they're organized is, I believe it's the first 8 guidelines are, the guidelines generally how they're laid out are in the form of, general dynamics or Baker Hughes sort of balancing. So the first 8 guidelines in particular set up presumptions. But of course, those presumptions are rebuttable depending on the facts and circumstances of a particular merger. And there's a whole section on the, common types of rebuttal evidence. And so the guide, and I say that only because one of the guideline Anora that you referenced is a part of those, one of the first 8. And so obviously facts and circumstances, as in all of this, will carry the day. But where that came from, I believe, is there is law on foreclosure, and and so I think the economics and that guideline borrowed heavily, from that law.
That makes sense.
Kades, is there anything else?
Yeah, so I would just add a couple points, right? So in a broad sense, but the way I would sort of explain it is, look, if vertical agreements, if you're under the law, start triggering concerns at a certain 50% level, it's not unreasonable in a statute where you're concerned about stopping mergers that may substantially have an anti-competitive effect that you would look to, well, when would the conduct post-merger be problematic, and say, does this merger create those conditions? And the second point, and this is maybe maybe our own fault, that and by our I mean the antitrust bar, right? In the guidelines, when we use the guidelines are not the law, right? Just because we say something's a presumption, what we're really saying, or right, it means it's about how it triggers our analysis. When we go to court, if it's what the courts say is a presumption, right? Like, we could raise the HHIs to 9,000, we could cut them to 100. Philadelphia National Bank continues to be the controlling authority of what the legal presumption is. And I think there's a tendency of people to sort of read the guidelines as a statement of law, when what it is, it's a statement of how we analyze a merger and when we raised concerns about a merger. But the ultimate decision about when we sue is always tied to the legal standard, which has not changed since the Seller-Kefauver Anti-Merger Act was passed.
Let's stay on the vertical versus horizontal merger issue. When you merge, when you put them all in one set of guidelines, doesn't that really expand how many cases are going to be reviewed? And as a result, lowering the HHI levels is also going to increase the burden, not only on businesses, but on the agencies as well.
Right. The thing to remember is, until 2010, I believe, right, the guidelines, there were just merger guidelines, and they were all together. And I don't know that, I'm not sure I understand whether those are two documents or one document is radically changes what gets reviewed or not. I think the benefit of what we see as the benefit of putting together goes back to this point, that what we're interested and what we're trying to convey is, we're looking at how competition operates and how the merger changes that and what the impact is. And so, right, I'm going to get some bonus points here from Anora by saying, right, like, it, if you spend your time trying to take three-dimensional chess and put it into the horizontal or vertical, you're likely to on both sides, you're likely to miss problems that exist, but also you may miss like justifications or benefits of mergers, because you've put them in boxes that actually don't really reflect the competition that's occurring. So I think in terms of putting together, I think the benefit here is it's helping to identify that what we're interested in is how competition is functioning. And then on the changing on the HHIs, right? So it's sort of right. It's really in some sense, the 2010 guidelines are the outliers, right? The 1800 number is a number that was in use since the early 80s. I've not heard that number was unduly burdensome. And when they moved the guidelines in 2010, it was not because they said, oh, look, here's a bunch of literature that says 18 to 2,500 turns out never to be a problem, or rarely to be a problem. I think they were the agencies were, fairly candid. Like, this reflects our practice, but that practice always reflects resources. I think the unintended consequences is, once you move them, then everyone assumes that it becomes the floor, right? So it was all of a sudden people were like, well, if you're below 2,500, you're in the free and clear. I don't think that was the intent. And it certainly wasn't the case that when they were 1,800, we challenged everything between 1,800 and 2,500. And so I think going back to 1,800 is not going to create a great burden, but I think it does provide better transparency to the industry that we may be concerned about mergers between 1,800 to 2,500. We are going to look at those mergers. We are going to apply, the guidelines which have the rebuttal. We're not saying, right, and we're going to go through that analysis, but right. So, I think that it better reflects how we think about mergers.
I think I take from what your response is that the agency's resources and I guess natural logic and reason is gonna be the restraint on whether the agencies are gonna look at some cases right at the edges of the HHI and very extreme examples, right? So I guess some of the concern is connected with what have been stated in the merger guidelines as a trend toward concentration. And I want to give you an opportunity to talk about what agencies are concerned about it. And is it simply limited to catch zero acquisitions where any single one by itself perhaps would not be caught by existing guidelines?
So I'll take this one. So look, this again, as the discussion that you just had and the previous discussions we've talked about, I feel like a broken record, but this comes straight from the law. The Supreme Court has recognized that this is an important legal principle in Section 7 enforcement. And, frankly, you're right. I've seen some criticism of it. But I mean, if you're talking, let's say, for example, you've got a monopolist and a transaction would allow them to, gobble up a nascent competitive threat. I'm not sure how controversial that is as a theory. And so, there are, a lot of permutations of, potential fact patterns, I guess, that could facilitate an illegal trend towards concentration in violation of Section 7. But, this again is a distinction that though, I think the horizontal vertical paradigm falls away because there can be a lot of different transactions that can further a trend towards concentration or entrenched dominance. And so you could be talking about a serial acquisition standpoint. We could be at a tipping point where, you've got transactions that are going to tip a market structure, that kind of thing. And so this guideline is firmly grounded in the law and, modern economics, and is, again, something that we certainly think about as we evaluate a merger.
Sure. So I think we're sort of coming to the end of our time, but I want to point out one larger issue, and it's mostly about how the stakeholders are receiving these potential guidelines, and then ask you guys if you have something final that you want to say that you'd like to, that we haven't asked you about. I note that some critiques have said that these merger guideline changes are long overdue and that some think they went too far, some think they've gone not far enough. I'm wondering, and a number of people as I've spoken to people, I think of the old adage about if you have a settlement and both sides are unhappy, it's a good settlement. So the fact that you're getting critique from both sides might bode well, but I do have to note that at a July 20th Federalist Society event, Todd Zwicky called them moderate, and that's not exactly what you would expect from somebody on the Federalist side. So with that sort of big softball of summary of how we're, at least in the initial stages, hearing from the people that are going to be working with these guidelines and commenting on them and eventually administering them, what would each of you like to finish with as a final thought on this issue before we go to the silly Our Curious Amalgam puffery questions?
Andy, it's okay if I go first? Right. So sort of building on what, Andy sort of talked about, that the primary drafter is just extraordinary on both sides, but also the process internally. I was at the commission during the 2010 guidelines, and the input and involvement at the staff level was far greater here. It was really an important goal for John in particular that we talk to the staff about, and that they be their views as experts be incorporated. None of this is to say that this draft is perfect, and I'm happy to be any mistakes. You can blame me, but that's but the point here, this is a process, and if you have concern, if people have, we have a 60-day comment period, which is quite long, precisely because it's a process. We're open to listening. I've heard some critiques strike me as people, sort of reading the worst into what they see. And maybe the worst was just, we need to better explain something. Or maybe there are areas where we did get, where we need to change things. And I think that's the next step here. And I think that's the productive conversation to be having, as opposed to the sort of ideological, the assuming that we're not trying to do what we're saying we're trying to do, which is take the law, take the way markets work, and take the best economics and come up with a mode of analysis. And so, so I think I think people, a constructive process here is really important, and people should assume we're listening, because we are.
Yeah. One thing to be considered as a practical matter and as a constructive part of the constructive process is that how are the courts gonna think about that? Are you worried at all that courts might not be persuaded by some of the theories of harm, perhaps proposed or endorsed by the draft merger guidelines?
Look, I'll take this. First of all, let me just echo what Kades said. Although, if you do have problems with the guidelines, definitely blame him, not. But look, a healthy, constructive process requires us to get comments from, a lot of different constituencies, and so we welcome, comments, and some of them may be tough, and we may disagree with some of them, but some of them may be improvements that we either, didn't think through all the way. And some of them may be, as Kate has said, there's just some language changes that we need to make because the original intent wasn't coming through. So please, if you're out there, engage in the process. We welcome it. Look, I'm not going to comment on how we think judges are going to view these, other than saying a couple of things. One, look, in our system, judges obviously play a critical role in this area of the law, and we firmly and obviously totally respect them and their judgments. We did try to, as we've said a few times, one of the organizing principles is around the law. And so hopefully the lawyers, including judges, that's something that, can be noted. But look, our goal in this was to, as we said a few times, to be transparent about how the agencies run their process, but taking into account the core principles we've already discussed in terms of fidelity to the law, reflecting modern market realities, fidelity to modern economics, and trying to explain things in a user-friendly document. So hopefully if we satisfy those objectives, other things will fall in place.
Well, thank you so much, both of you. Now, as we explained when we were prepping, there are two follow-up questions that our listeners always want to hear our guests' views on, especially two guests as prominent in the antitrust world as you both are. Can you tell us something about yourself that people don't know if they only know you professionally?
Yes. So if you go to the National Gallery, there's a picture called Look Mickey. It's one of the most famous pop art pictures, and it's by Roy Lichtenstein, and it's a painting that looks like a comic book image. And so for a long time, nobody knew where that image came from. And the one person who knew wouldn't say. I actually am the one who found the original image. And so, that is probably the most important, the greatest contribution I've made to human civilization.
Where did you find it, or do you have to?
That's actually a really long story that I'm not going to share. It was a long internet search, and then looking in used books at old Disney books. So,
wow, called Luck Mickey, is that right?
Yes.
Okay.
I've also found out about Kades. He's a fantastic baker. So if you want an awesome cake or cupcake, Kades, maybe after his antitrust life, will go into work doing that.
Don't think you're getting out of telling us about yourself, Andy, by telling us more about it.
No, I just thought I'd brag about Kades. And during Halloween, he has some of the most awesome, home decorations for Halloween. So including around, organizing around major principles about the founding of our country and antitrust and other things. So True story,
Hey,
Kades.
Andy, a lot of money to say these things, but Andy, you can tell us about yourself.
Well, look, I could tell you that I'm a diehard Boston sports fan.
Okay, you can stop there.
I had my fifth, probably personally, the most interesting thing that people, when they find out, I had my fifth birthday in Tehran, Iran in 1978, right before before the revolution. And so we were over there doing my father's job. So I have flashbacks from that point in time, but fond memories. I guess professionally, the one thing I would say is a lot of my mentors in antitrust include people who were in the Bill Baxter antitrust division in the early 80s and 90s. And so one of the things that I really enjoy about this discipline is not only is it exciting because, in order to understand a particular matter, you really need to understand how businesses operate and make things and buy things and sell things and price things. But you get to, in this industry, get to know a lot of, great and well-respected people who have very different views on either politically or even on the proper levels of enforcement. And so it's been a great journey for me to have, be lucky enough to have the opportunity to sit in this chair during this time next to Kades' office and down the hall from, AAG Cantor and PDAG Mecki and others, but also having grown up with people in the bar whom I respect and admire and are mentors who have a different view on things. And so I think that's one of the great things about the profession.
That's terrific. And then Michael, let's end with you. Do you have any advice for young professionals and students who are interested in doing what you do?
Yeah. So I've been thinking about this, and when I was a younger or less experienced attorney, I was always afraid to reach out to more experienced attorneys and people I respected. It was like, well, they're busy. They won't want to hear from me. And I think that's a mistake. The few times I think it's really, as much as, and to be proactive and be an extrovert, even if you're not, and reach out to the folks, even if you haven't met them, what you'll find is that people actually really like helping new and younger attorneys, and it's the way you will learn, and it's a way. And now that, not to the, I certainly have never felt when people have reached out to me anything other than, oh, of course, I'm happy to talk to you. But I think that's just the best way, a great way to develop professionally and sort of overcome that natural sort of like, oh, I shouldn't, they're important. Nobody's important in this world, actually, unless they're sitting in the Oval Office. And most people actually really enjoy talking about what they know and sharing their knowledge, and we should all take advantage of that.
All right, Andy, what do you have to say to young professionals and students who are interested in following in your footsteps?
Yeah, well, I think Kades' advice is great. I guess the one thing I would layer on is always know the facts. And so, early in your career, you may not know the law or the process as well as some folks who have more gray hair, but you can put yourself in a very unique and valuable position if you know the facts better than anybody else. And so I would suggest that. And then the second thing is more general, just always take charge of your career. So, trying to find those mentors and trying to get new experiences, but also, be strategic about your career and what you want to do and go after it.
Well, thank you both so much. I also would like to point out that we are going to have the URL for Look Mickey on our website so that you will be able to actually look at what Michael...
People might be confused that first piece of extended reading is the merger guidelines and the second is Look Mickey.
Well, that's why our Curious Amalgam is such an interesting podcast to listen to. Right. So thank you both, and thank you, Anora, and we're signing off. Thank you.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.